So a very warm welcome to everyone. Thank you very much for taking the time to join us this afternoon. Appreciate everyone's very busy in this modern world that we live in, so taking the time out to spend some time with us is much appreciated. So thank you very much. Just letting the last few people in now. So for those that don't know, Blackfoot CyberSecurity, we've been going for 17 years this year. We're a leading in information security and data protection assurance and management business. We acquired GDPR.IE about a couple of years ago now, so this is to sort of strengthen our foothold certainly within the European market. But Blackfoot services global clients, and our GDPR brand very much services the European market. So some of you, I see some familiar names here and some less familiar names. So I know some of you are DPOs. Some of you might want to be a DPO. Some of you might not want to be a DPO. You may work with DPOs, or you may not have a DPO and you feel that perhaps your organisation should have one. So hopefully I've covered all bases there, and we will certainly aim to cover those scenarios off within today's session. Just want to quickly mention that if you enjoy or have enjoyed listening to both myself and Sharp today, we do have a podcast. We've been running our podcast for about almost a year now, and with it's certainly been quite successful. So if you want to listen or learn more about that, you can find us on YouTube. It's the Privacy Impact Shop. You can also find that on our website if you want to watch that, or listen on all of the major podcast channels, Spotify, Amazon, etc., etc. I'd like to encourage you to use the Q&A function. So please feel free to ask questions during the presentation, as well as at the end, and we'll look to answer as many, Sharp will look to answer as many of those questions as possible. I like to put him on the spot, so let's
thank you for that.
That's all right. I like to make good use of that. So do fire off as many questions as you want to. And as I say, we'll look to cover those off at the end using that Q&A function. So that just leaves me to say thank you once again for joining us. And I would like to now hand over to my good friend and colleague, Mr. Shab Al-Baghdadi.
Thank you, Ben. So afternoon, everyone. Thanks for, as Ben said, giving up your time today. This is the agenda which we're going to go through. It's quite a bit to get through. Before I start, it's probably just worth mentioning why we put this together. So one of the main reasons was that as we've been sort of offering data protection services for years now, we still find that there is quite a bit of confusion about the role of a data protection officer from both sides of the fence, really, from the data protection officer's perspective in certain circumstances, and organisations looking to appoint a data protection officer. So today really is about maybe trying to clarify some of those points, allowing organisations and individuals that are doing the role or need to implement or take on a data protection officer, they sort of get a clearer understanding of what's required from both sides. And that's important. It's important because if everybody knows what their roles, responsibilities are, and the expectations from each other, those relationships tends to be more harmonious, and everybody gets the best from that working relationship. So that's one of the main reasons. The other reason was we wanted to sort of maybe touch on how the role is changing. There's a lot happening around the use of data, personal data. That's the sort of world I live in. Both from a legislative point of view and the implementation of technology, and what does that mean for the role, and how you need to sort of adjust to that. So that's really setting the scene why we put this together and why the agenda is as it sort of is there. So with that in mind, let's start jumping into this. And as Ben said, please, I encourage you to ask any questions, pop them in the Q&A, and Ben will pick the most difficult for me to answer at the end, I'm sure. So I think the first thing to understand is, what is a data protection officer? Well, in essence, it's an internal regulator for data protection requirements. The data protection officer there is to make sure that the organisation is meeting its requirements around the General Data Protection Regulation and other relevant data protection laws and regulations. And we can see this defined, or we start to get an idea of this under recital 97 of the regulation. So you should assist the control or processor to monitor internal compliance with the regulation. So you are not, as a data protection officer, necessarily a doer of a data protection program. You are there to monitor if the data protection program is adequate and meeting the requirements from a compliance position. So you have certain tasks in order to allow you to achieve that, and we'll look at some of those in a moment. I think what's worth now taking a look at when we say you're there to monitor the internal compliance with the regulation, what does that actually look like? What is monitoring compliance from a data protection perspective mean? So at this point, let's take a quick look at what are some of the requirements that a data protection officer needs to be in a position to monitor. So these really are the principles of a regulation that organisations need to follow and adhere to. And I'm not going to go into all of these in depth. That may be something, another piece we can discuss. If you need clarification on that, certainly we can help on that. But this is the sort of area where you need to meet the principles such as fairness, data minimization, data accuracy, purpose limitation, those sorts of principles that organizations are required to demonstrate that they are meeting when processing personal data. Lawfulness of processing. Consent as one of the lawful bases for processing data is, from a European perspective, how can I put it? There's a lot of requirements around being able to demonstrate valid consent, specifically as well if you intend to process children's personal information. Finding the right exemptions for processing special categories of data, and not necessarily also if you are processing data which might relate to criminal convictions or offences, perhaps if you're doing background checks on employees and that sort of thing. You also, as a data protection officer, need to make sure that the organisation is meeting the obligations of providing the rights to individuals. So again, this is just a snapshot of some of those rights, and I'm not going to dive into all of them. I'll maybe pick out one or two that, you know, from experience perhaps need a little bit of clarification or do present some particular challenges for organizations to implement. So I think everybody knows about the right of access. No, certainly members of the public know about the right of access, and we do see those increasing more and more. You have a right to rectification if it's incomplete or incorrect. I want to just look a little bit of a right to erasure, the right to be forgotten, because there is a little bit of confusion around this particular right. So if data is no longer needed for legitimate business purposes or regulatory requirement, individuals can ask for it to be deleted. The right to be forgotten sort of extends that, really. And if you have shared data or made data public, then you have an obligation to try and remove those publicly posted material, excuse me, or indeed contact third parties that may have data which has been provided by you and meet the request of a data subject to have that deleted. So that puts a bit more of a sort of an additional operational burden on organizations. Again, you have a right to restriction of processing. This isn't deletion. This is maybe where there's a dispute between individuals and the organization where you might say it's not, you know, you're not treating me fairly or it's unlawful. And that means you have to suspend that processing operation. So if you think that you're processing data on, you know, potentially thousands of people, could you pick one individual's processing operations out and be able to suspend that operation? Again, right to data portability. This is new. This is where I, as an individual, can come to you and say, look, I don't want you necessarily to send the data to me, but in certain circumstances, I can request that you send the data to a third party, perhaps a competitor of a company. And the idea behind this, right, is to empower individuals in terms of the use of their data, not to give them that lock-in. So organizations, don't control completely their data. They have the ability to move data around and, in fact, sort of commercialize it. Automated decision making, including profiling. So this individuals have a right not to be subject to it, and be provided details of the logic and what's going on behind those sort of decisions. This is becoming more and more pertinent with the use of AI, and this particular right that individuals have is never really designed for where we are today in terms of the processing of personal data in relation to AI. So this one is becoming, more of a challenge to understand how it is implemented in today's world with automated decisions, but also utilizing AI, and providing the logic behind that can become a challenge. And then finally, restrictions, because most of these rights that individuals have limitations on them. And the data protection officer will need to understand when individuals can apply those rights, when they might be restricted, and those restrictions don't come across as trying to inhibit individuals' fundamental rights and freedoms. We can look at what the controllers and processors, those that are processing data, also need to consider. So they shall implement appropriate technical and organizational measures to ensure, be able to demonstrate that processing is performed in accordance with the regulation. And they should be reviewed on an ongoing basis. So this is really sort of putting in some sort of quality control, constant monitoring of your program. This will include the implementation of appropriate data protection policies by the controller. So the data protection officer really needs to understand, is the policy appropriate to the organization and in the context of that relationship? So are you processing special categories of data? What's your relationship? Do you collect information indirectly, directly? So the data protection officer will also need to understand that. Adhere to approved codes of conduct and certification mechanisms if you've signed up to them. Currently, we don't really have any of those. The only certification mechanism that has been approved is in Luxembourg. Records of processing activities. This is a ROPA. A lot of organizations can find this a bit of a struggle. But in essence, you need to identify all of the reasons why you are processing personal information, have that recorded and available to a regulator on request. And there are other mandated requirements within that, such as for security measures. Is the data being transferred overseas? What is the time periods for that data that is being processed, etc. We could also see that data protection by design and by default should be implemented where appropriate and required. If you're in a joint controller relationship, have the right agreements been put in place there, including with data processors as well. And you should cooperate with the supervisory authority. So you do have a obligation to cooperate with the supervisory authority when those requests come in. Is the security of processing appropriate to the level of risk that personal data might have an impact to individuals? Also, notification of a personal data breach. So when to notify both the supervisory authority and individuals. So that's a bit of a snapshot of what a data protection officer should be doing in being able to demonstrate or tell an organization, yes, you are meeting your compliance requirements. So hopefully from that, why I've put that in is to just give an idea of the scope of the role. So it's not just something where you come in and go, yeah, that kind of looks to be okay, and everything's sort of all good, or there's a few issues here. If you think about all of those sort of various items and areas that a data protection officer needs to be able to tell an organization how it is performing in those roles, this can suddenly turn into quite a big role. So based on that, when does an organization need to appoint a DPO? Well, there are various circumstances when that appears. One, when the law says, or when regulators mandate, or organizations want to demonstrate compliance. So the law, when I say the law, I'm talking about the General Data Protection Regulation, sets out three sort of criteria really when you need a data protection officer. One, if you are a public authority or body, so councils, that sort of thing, they are mandated to have a data protection officer. The other two are a bit more open to interpretation. So the core activities of a controllable processor can operate, which involves large-scale processing or monitoring, or you are processing special categories of data or monitoring individuals on a large scale. So in order to determine that, there is guidance from regulators. Here in the UK, it's the ICO or the Data Protection Commissioner in Ireland, or any of the other jurisdictions where you might need to appoint a data protection officer, can provide guidance. Or if you need any assistance on that, feel free to reach out, and we can help you identify if there is a need for that. Now, the other situation is where regulators might mandate there is a need for a data protection officer. So this is outside of what the GDPR says. So member states, countries within the EU can also determine and apply other reasons why a data protection officer might be required. And just to give you an idea of a flavour of what that might be, I've put an example here of when in Germany, a data protection officer is required. So if you are processing data which involves at least 20 employees, there is a requirement to appoint a data protection officer. Or if you are transferring commercially, for commercial reasons, data, even if it is anonymized, then there is a requirement to appoint a data protection officer. So you can see that in that particular jurisdiction, the data protection officer role was seen as an integral part of the General Data Protection Regulation requirements. And there's a lot of external data protection officers in Germany, because this can, in many cases, put quite a burden on organizations to start appointing a data protection officer. Now, you can also appoint a data protection officer where it isn't mandated by a regulator, or there isn't a legal requirement to appoint a data protection officer. This can include not required, so you don't necessarily have a legal obligation or it's mandated, but you have made that choice that you want to appoint a data protection officer. So what would be the benefit? Well, first thing to understand, even if it is a voluntary appointment, all of the obligations of the regulations still apply. And we'll come on to, in a moment, what those obligations and requirements would look like. So what are your responsibilities to a data protection officer? Because it's not as simply as just going, okay, I've got you on an employment contract, you're going off, you're doing your role, fantastic. You have obligations. And the point here is, even if it's a voluntary appointment, those obligations and requirements still exist. So why do it? Well, it's helpful for designating a data protection officer to ensure that the organisation is running its data processing activities and its program is compliant and meeting the requirements of the regulation. Excuse me. What we're also seeing more and more is it's not just the motivations for this are changing. And one is certainly because data governance is becoming more of a priority for organizations that want to use data in order to get the benefits of AI. Then the data protection officer is becoming a more of a crucial role within the whole data governance and use piece to ensure that the data can be used lawfully. It is meeting expectations of individuals. So that's one drive for why we're seeing data protection officers being appointed outside of a legal requirement. The second reason is that organizations, as part of a due diligence process, either if they're being onboarded as a vendor or indeed they are looking to get involved in the mergers and acquisitions market, they're looking to raise capital. Those third parties are starting to say, okay, you know, we're obviously, you know, very mature in cybersecurity in terms of asking those questions. Other regulatory requirements such as PCI, etc. Are you meeting those? But data protection is becoming a bigger consideration when making these sort of business decisions. And what that means is that we are seeing organizations start to see this as a business value proposition rather than just a legal or regulatory compliance issue. Because your data protection officer really is the cornerstone, or the assurance, I should say, that you are processing personal data in a compliant fashion. So with this in mind, what is the DPO doing? What does your DPO do for you? What is the role or the point of the data protection officer? So it provides provide an independent, unbiased view of the organization's data protection position. And we'll see in a moment why some of the requirements and obligations that organizations have to their data protection officer, they are there to support and make sure that those obligations and this unbiased sort of almost speaking truth to power in your position can be done effectively. So you are there as a data protectioner to inform the controller, the employees who carry out processing of their obligations pursuant of a regulation and other union and member state data protection provisions. So it's just worth also taking a note at this moment that although this is very focused around the general data protection regulation, as a data protection officer, you need to be au fait and understand other relevant data protection laws. So that can include the use of personal data from an employment perspective, when using data in relation to cookies, online tracking technologies that might direct marketing, etc. You need to understand if there are other applicable laws that could affect the use of an individual's personal information. Provide advice on data protection impact assessments. Now, this is when they should be done and how they should be done. So it's not necessarily what needs to be in the data protection impact assessment, but it's about advising the organization on an appropriate methodology which is consistent, so we get consistent results on these. Whether they should be done internally or an external body should, a consultancy firm, legal firm, etc., should do these on behalf of the organization. They should be reported and maintain documentation. You are also there to provide advice when regarding data protection impact assessments and monitoring the performance of these. So it's not only to make sure that they are being carried out correctly in relation to the context of the organization, but also that they have been implemented and that they are being followed through. That is why a lot of data protection impact assessments you will see, there is a question, has the advice and guidance of a data protection officer been taken in this? Monitor the performance of the organization in meeting its requirements to make sure that collect. So in order to do these roles, the data protection officer should be able to collect information to identify processing activities. So the data protection officer has that role of understanding and getting all of the information in relation to what is happening within the organization. Analyze, check the compliance position. So once they've gathered the information in relation to what is happening with personal information, they need to be able to analyze that. They then should provide such activities as taking audits. So they need to understand audit process. They also need to be able to train individuals. Now, it could be that you're using an external training organization, in which case it could be quite a large organization where the data protection officer doesn't have the scope or bandwidth to train all of the staff. In that case, the data protection officer will be there to ensure that the training being provided is adequate, suitable, and relevant. They act as a contact point for supervisory authorities. So any inquiries about your current position, what you're doing, they are the point of contact for the regulators, and they shall perform his role or her role with due regard for the risk associated with processing, taking into account the nature, scope, context, and purpose of processing. So that last piece is really saying that obviously, if you're a multi-billion international organization, you as a data protection officer, you will take a certain approach to that. If you are a smaller startup tech firm, you need to be able to understand and think about what that organization needs and apply the appropriate level of due diligence and understanding to the compliance requirements. Which means as a data protection officer, you not only need auditing skills, you need to be able to identify and understand risk and report that risk in an appropriate fashion, which is clearly understood. So what do you need to do for the data protection officer? So this is really about the organization's commitment to the DPO role. Because as I said earlier, this isn't really just about taking somebody on and then sort of saying, okay, we've given you the role, it's over to you. You have commitments to that position as a organization. So we can look at some of these. So full access to all processing activities. So this could in essence mean that, you know, it could be quite sensitive information, such as mergers, acquisitions, divestitures of part of the organization, employees' data that may relate to disciplinary hearings, referral to occupational health, etc., or, you know, customers, patients, clients' data that could be sensitive in nature. You should support the data protection officer. What does that mean? Well, active support from the senior management. So there needs to be buy-in from the senior leadership, and I would say a champion within the organization to support the data protection officer and lend credibility to that role. Sufficient time for the data protection officer to fulfill their duties. So have you allowed that? You should also provide financial resources, infrastructure, and staff where appropriate to allow the data protection officer to carry out their roles. Communicate the DPO designation to all staff and contractors, I'd suggest. And this really is to show the importance of a role part of the organization, that you see it as something that is imperative to the compliance position of the company. And again, provide access to other services within the organization. That can mean vendors, data processors, supporting parties. Do they know who they are? Have they got the authority to access those third parties which support you as an organization meeting your requirements? And continuous training. You have an obligation to make sure that the data protection officer is up to date, continually given the resources so that they can keep abreast of changes within regulations and new issues that are coming down the line. So again, complete independence. So you can see here that the organization, the data protection officer does not receive any instruction regarding how they exercise these tasks. So how you implement these requirements as a DPO, you cannot be given instruction from the organization. And this is to allow the independence of the data protection officer. Not to be dismissed or penalized or sort of, badgered in any way. Why? To protect and enable the unbiased provision of information. You have the officer shall directly report to the highest management within the organization, and this is to avoid information being misinterpreted. And you may contact the data protection officer with regards to all issues relating to data protection of personal information. So how are you going to enable individuals and manage that requirement that the data protection officer is the point of contact? Again, you can see here the data protection officer may fulfill other tasks and duties within the organization. If these duties do not inhibit the duties of the DPO. So, of course, if you are going to have more than one role as a DPO, how is the organization ensuring that they don't come, you have the time in order to be able to do that? You shall ensure that any such tasks and duties do not result in conflict. So I've just put together a couple of examples here of what might constitute a conflict of roles. So you can't be determining why data processing is occurring and then on top of that be the DPO for that particular process. You can't be a board member and you can't be a CISO because those are clearly defined conflicts of interest. So let's look quickly at some risks and benefits of these positions. So what do you need to be aware of when making a decision regards a role? And maybe this goes both ways for the organization and the data protection officer. So if you are a group of organizations, so you have operations sort of in different jurisdictions within the EU, you can have one DPO which is appointed for various jurisdictions. So that's you need to consider how you're going to actually operationalize that requirement if you do need to be designated in different jurisdictions. How will the organisation of the DPO allocate effective time to do these if you are, acting as a DPO for multiple jurisdictions? Who else needs to be part of a team? And that's really something more generally as a DPO, even if you are in one particular jurisdiction. The controller and processor shall again publish contact details of a data protection officer. Generally speaking, a named individual should be on the register at the regulator, generally speaking. You don't need to be, it could be an organisation providing the service as an outsourced data protection officer, but an individual normally needs to be named. So considerations of having an in-house data protection officer, so internal member of staff, something like that. Will any other role suffer if this individual is doing more than one role? The ongoing cost of an internal data protection officer, because we've just looked at some of the requirements and obligations companies have to this role, and will they have the authority, and how are you going to ensure independence? You can obviously outsource the role, and if that is the case, a couple of things. Do they cover all? Does this outsourced service cover all the requirements as we've just gone through? And how will the provider interact with the organisation if they are external? And again, in terms of independence of the relationship, that is a consideration as well. So a couple of other things here. A person with expert knowledge of data protection law and processing. So how are you going to identify if the individual that is undertaking this role has the experience? How are they demonstrating their ability to perform the role through certification? What is the most appropriate certification that they need for this role in relation to what they may be required to do? Are you in financial services? Are you in pharmaceuticals? Are you in health, etc.? The necessary level of expert knowledge. So how long have they been in the role? Have they worked for anyone else? How can they prove their ability to fulfill this role effectively? So does the DPO understand risk? This is such an important part of the role. What level of expertise do they need, and methodologies for completing DPIAs? Can they work independently because they are not taking operational advice or requirements from the organisation? And does the DPO understand auditing requirements or methodologies? How will they monitor changes to requirements in legislation, new technologies? So for organisations that are looking to appoint a DPO, a couple of things I would suggest that are sort of good sort of housekeeping and practices. One, determine if a DPO is required legally, and if not, and you are not going to appoint one, that should be recorded. Because if you do need a data protection officer and you fail to appoint one, that is a technical breach of a regulation, and organisations could well be fined for that. How will the DPO manage changes in relation to AI tooling adoption? Do they understand AI? Do they understand where these risks, new risks that are being introduced to organisation, how they affect individuals, where the use of AI and data protection principles and requirements may conflict? The UK's Data Protection Use and Access Act. So this is coming in. So just a sort of snapshot of some of the new requirements that a data protection officer will need to understand. So the Act includes the ability to compel witnesses and issue fines of up to 17.5 million of 4% for the e-privacy or cookie directive not being followed. So previously it's up to 500,000. Now it's much bigger. It's in line with the regulation. So really it's about getting a good grip and understanding of tracking technologies, marketing, and understanding what these changes might mean to the organisation. Introducing new requirements for organisations to handle all data complaints from individuals, not just those related to data subject rights. So again, this is going to expand the role of a data protection officer and potentially add additional operational requirements to the role. Controllers must have clear procedures for handling complaints. So you need a very robust complaints procedure and respond to them within a specific time frame. So you can see that this is expanding what the data protection officer may need to do in terms of just meeting data subjects and regulators' new requirements. And new powers to request organisations to produce reports, technical reports, rather than just general provisions of information such as records of processing activities. So what that technical report looks like, we're waiting to see and get clarification on that. Also legal notices to data controllers electronically without their prior consent. This is very much more about international or organisations that are outside of the EU or UK, I should say, and it allows regulators to serve notice on them and compel them to provide information or be fined or undertakings to suspend data processing. This new requirement enables that and helps that to be facilitated more simply. So there's quite a lot there. I know there's a bit of a sort of huge amount of information being provided. Are there any questions, or is everybody too stunned to ask any questions?
There's quite a lot to digest there.
There was quite a lot there to digest.
Short space of time.
Hopefully it was helpful.
I'm sure it was. If not, I'm sure you'll give a full refund to all those that attended.
This is a free event, so refunds can be provided.
We have had, I've got three questions. So the first one's nice and easy. Do we get a copy of these slides? Yes, absolutely. More than happy to provide a copy of the slides. And I think we'll be able to share a recording of this as well, should you wish to relive it or perhaps share it with colleagues if needed. So that's that one, nice and easy. The next one is, will companies with a DPO be less likely to be fined if the company has a security breach?
It's a good question. So certainly if an organisation does have a data protection officer and they've taken the advice of the DPO, and let's say there's a security breach through hacking or something like that, and it has caused harm to individuals, but they've taken the advice of a data protection officer, that is normally taken into regard because it is seen as a core element to the data protection program, and that normally reduces any penalties or actions that regulators will necessarily place on an organisation, assuming that the organisation hasn't completely ignored the data protection officer.
Perfect, thank you. I've got one more. If anybody does have any others, please do use the Q&A function, as we've got a couple of more minutes left, but I'll do the last one that I've got, and that is, do you think DPOs should be paid a bonus, or could that influence their decision making?
Depends what the bonus is against, really. So what might be difficult here is where it could influence a data protection officer is if a bonus is related to, if a data protection officer is going to say, look, your processing is unlawful and my advice is to stop it, and that could potentially affect the performance of the organization's financial position. That would be a case where a bonus scheme for a data protection officer could be deemed as prejudicing their position. But if a bonus scheme isn't related to that and is related to other key performance indicators in terms of how the data protection officer is performing their role, then yes, I think there is an argument that a bonus should be paid to a data protection officer. But again, that is something that requires quite a bit of consideration.
Fantastic. Thanks, Sharp. Any more for any more? I think that is everything. So yeah, I think once again, thank you so much for taking the time to join us this afternoon. Do feel free to reach out with any further questions, or if you want to inquire about any of our services, including certified training. And we will reach out to share the content from today. So it just leaves me to say thank you once again and enjoy the rest of your day.
Sorry, there's one more question then, Ben.
Where's that? Ah, yes. Could getting a VDPO or fractional DPO be considered a quick fix, or just paying lip service? Thank you very much.
Ooh. So I'll answer this as straightforward as I can. The same question applies to if you're appointing an internal data protection officer. So it could be seen as a quick fix if the data protection officer hasn't got the skills and ability, which hopefully today's given us a sort of snapshot of what that might look like, or two, the organisation isn't going to support that role effectively. So whether it could be seen as lip service if the organisation's just going to say, hey, I saw you walking down the corridor, you're now the data protection officer, good luck. And in the same way, if you're not choosing the right organisation and the service they are providing doesn't really align to your requirements, then yes, it could just be seen as lip service. And I'm not here to recommend or berate any organisations, but in my time, I have seen this role outsourced in probably the least effective way possible, where someone might turn up once a year and go, yeah, okay, everything sort of seems fine, and then leave. So yes, absolutely, it could be if you don't have the right external data protection officer.
Thank you so much. All right, we'll leave it there. Thank you very much, and we'll hopefully we'll speak to you very soon. Take care. Thanks very much. Bye.
Thanks for your time. Bye now.